What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we have a myriad of topics. Welcome, of course, to the Friday live stream. One of the high points of every week of mine is getting to spend some time with you guys and talk about all sorts of weird legal stuff. So, bear with me a second. I am woefully unprepared today. So I'm going to get things set up while I chat. So if my eyes are going all over the place, so why is because I have no idea what I'm doing. Let me see. And you're going to see a bunch of documents start flashing up on the side of the screen. Ignore those. Just ignore that. Because that is me getting everything set up still. I didn't want to be super late getting started. That Hamilton, that is your prerogative, buddy. you can do that if you want. Getting wrapped up in the sex ring. I don't know if that's the best move. Don't know if that's the best move at all, but it is a move that some people made, apparently to their detriment. But we'll talk about that a little bit. So we've got a bunch of documents from her. And I'm loading those up. Oh, she says, can't catch the stream, but have you decided if you'll come to Road Rage Dallas? Much love from the best state in the union. Man, I cannot make it to Road Rage Dallas. And it is really frustrating for me. So I apologize. I will not be there. It is, I blame entirely Diego, who picked the worst, pretty much the worst day in all of June for me, because I will be unable to be in Texas on the 30th. There's just no way for me to do it. Lady Rackets and I have been over it a couple times to see if there was any possible way, and there just isn't. So let's see, what do we have here? Ooh, redacted documents. That's exciting. Probably not. All right, so I've got a million different documents to go through, and we'll see what happens. And I apologize for the ugliness of having a legal print off in here, but my typical source, which is Westlaw, is having some sort of maintenance right now, and I am unable to get access to the documents. I mean, I can find them, I just can't print them or get PDFs of them. So that's very convenient, of course. So I have to resort to things like legal and actually going to the Court of Appeals to pull a document. Let's see. Did you see that Russell Greer's brothel lawsuit was dismissed this week? No, I haven't seen that yet. But that guy is so brief side story, guys. I'm in a business network in my small town, and we do this some of you guys may actually know what the business network is. I won't dox it on here. But we do weekly meetings, and as part of this networking meeting, you do like a 1-minute commercial for your business and just kind of tell people what you're looking for referrals and stuff like that. But then in our chapter, like every 6 months or so, you get to do a full 10-minute presentation. And mine was set for June 13th, which was not going to be a convenient day. But the person who was giving their presentation this week actually broke their foot or ankle or something, and therefore were unable to. So they sent out a message like 2 days prior saying, hey, can anyone else step in and do this? And I said, well, I don't want to do mine on my scheduled date, so I'll do it in 2 days. I had no idea what to talk about. So I have 10 minutes to fill. And of course, you guys know I can fill like hours talking about all sorts of worthless stuff. But I had 10 minutes to fill and no plan. So while I was sitting there during the meeting, waiting to do this, I decided to just tell them the story of Russell Greer suing Taylor Swift, and turned out rather well. So I guess thank you, Russell Greer, for giving me a 10-minute presentation when I did not have anything ready to go. Let's see. What do we got tonight? What do we got? I am going to go with this Basil Hayden's. So I got this Basil Hayden's at a Kentucky Derby party. It was a door prize because my stupid horse came in 4th place, which yes means that I had our horses were assigned by just where we sat, and I had I had the worst horse. Good job. Good job. What are we talking about? Whatever. Anyway, Andrew, the reason I haven't taken a drink of Lagavulin since they spurned me is not because they spurned me. It's because I have a shelf full of liquor. And I don't want to go out and buy like an $85 bottle of liquor until I start running out. So, you know, when this present stash is gone, then maybe I'll get another bottle, but I'm not going to go. I have a lot of fine whiskey behind me, and I'm certainly not going to go purchase another bottle at this time. So YouTube is giving me some whiny thing about bad video settings, and I'm sorry for the delay again, but let's see. Currently, keyframes are not being sent often enough, which will cause buffering. The current keyframe frequency is 8.4 seconds. Note that ingestion ... Very helpful. I don't care. I'm not doing anything that I normally don't do. So when everything goes, down the tubes. Okay, guys. So as you may have seen, if you follow this channel, you may have seen that this past week, I had a very short video, much shorter than any of my normal videos, just 1.5 minutes, and it was a how-to guide on defamation and stalking and harassment and all of that stuff. I think it was just defamation, a how-to guide. So the context, the backstory of that, of course, is that last Friday's stream, which was about Maddox's inappropriate, and I don't mean like inappropriate as in somehow vulgar or anything like that. I don't care. His inappropriate response to someone, where the appropriate response to that person was just to block them, right? Just block them. Don't feed the troll, if you want to look at it that way. But Maddox didn't do that. So I discussed it, and I personally believe I was pretty fair to Maddox and anyone else involved in that. I thought it was rather even keel. And then we talked about Landau's lawsuit against Viacom, representing the grandson of Moe from the Three Stooges, which, again, I thought was pretty even-handed. So whatever. But that stream was reported prior to it even started as being, defamation and calling for threats and attacks and stuff like that, which is, of course, ludicrous. So I did the little short video with the appropriate response. But today I'd like to open this conversation with a little bit of discussion about defamation and about stalking and about these sorts of crimes, harassment, all of that stuff. These allegations that keep getting thrown out. Let's look at what the court actually says about them, and I guess that'll help us analyze whether something defamatory is being said. And Mm. Before we get too far, please drink responsibly. All right, there we go. That's true. That's true. They do go backwards through time. All right. Okay. Last bit before we dive into documents, because I'm still bad at this. If you want to, 2 ways to get a hold of me during this stream. The best way is, of course, a super chat, which does cost money, and I recognize that not everybody wants to spend money to talk to me, and that's fine. Of course, I appreciate super chats very much, and if you send me a super chat, I will address it right away. If you don't send me a super chat, you can use @Rekieta Law, as you'll note in the chat has been done a couple times, and it will show up on my screen. I may miss it. It depends on what the chat's doing. It depends on if I'm ranting or something like that. So if eventually we'll get to a point where there's some open question time, and I will take those questions just sort of in a row. But until we get to that, I'm really going to focus on what we're doing with the documents, and then any super chats that come through, like this one from Larry Bernard. When you respond to sociopaths with sociopathy, the court can't fix that problem. Money won't ever make you whole. That's that's true. That's a good point. And speaking of sociopathy, and I hate to tangent, but guys, I love the internet. It's the greatest place on earth. It's where you can find the funniest people. I missed your super chat earlier. Oh, I did. I'll get to it in just a second. Thank you for bringing that up. And guys, if I ever miss a super chat, feel free to call me out and say, hey, dummy, you missed one. If you guys go and look at it's the most recent Poppy video that I did on my channel. Go into the comments and find my dude Socratic Truths. Where's your Wendy's costume? I don't have a Wendy's costume. I'm missing that joke, I think, and now I'm sad. You gotta go find the comment thread by Socratic Truths. This guy is fantastic. I am apparently, possibly, a COINTELPRO JTRIG government agent, and this whole channel, its purpose is to basically, I guess, run some sort of government counterintelligence on the Poppy community. So you guys, like, I'm gonna do a video on this guy because he's great. So go check that out. If you want just a chuckle, it's on the most recent Poppy video. Again, Socratic Truths. And Socratic, if you're out there watching this, buddy, I love you. You're my best friend. And I'm not sure if I'm the government agent or you are, because you are very knowledgeable on the subject. And I think you might have inside information. Thank you very much, Pizza Wolf. And then let me get back to Spookmeyer. Spookmeyer. Nick, can you sue... could you sue Landwy for pain and suffering from reading his horrendous legal documents and get for him to pay for your whiskey cabinet? I should be able to. But I think the honest answer is that I am an intervening cause. So when you have a negligence action, like let's say Landau owes a duty to the public to not negligently draft documents that would cause harm to the reader, but you have an intervening cause, I have no requirement to read these documents. I'm only doing it out of the desire to inform you guys what the legal goings on are in the world. So I'm undertaking an extra step which intervenes on the normal course of events, and that kind of takes away causation from Kevin Landau and puts it squarely in my lap. So I am the proximate cause rather than he, although it is a little offensive. Ashley Princess says, Nick Rekieta confirmed deep state agent. Yep. Absolutely. Absolutely. What's up, Pizza Wolf? Thanks, man. And Pizza Wolf, I plan on still stopping by the shop because I will be in Texas. I just will not be there for road rage. So, you know, and I definitely we should definitely meet up and grab a sip of whiskey or something like that. So we can sue you? No. Please don't. But yeah, we'll definitely swing by, and I'll keep in touch, you know, as the date gets closer. But and I'll let you know when we'll be in your neck of the woods. Whew. All right, guys. So we're gonna talk about harassment, defamation, and stalking in that order, and then we will move on to Allison Mack being a sex cult recruiter. So that sounds good. So the first, I only have 2 cases. I don't have a harassment case pulled in here, and there's a specific reason I don't. Okay, so the reason I don't have a harassment case is because there isn't a common law harassment. Okay, so there's a couple types of law. The important ones to remember are the common law and statutory law. For the purposes of this conversation, those are the important ones to remember. Statutory law is a law implemented by statute or a law written by Congress and approved by either a president or a governor and signed into law. It's recorded. Also, city ordinances and stuff like that. So that's the body of statutory law that's out there. And then you also have the common law. And this would be claims that arise under, I guess, issues and solutions that have come about through the court process over the past 600-ish years. Okay? So common law, like many property claims, for example, arise under the common law because our system of property is derived from the English common law, where we went from ownership by one ruling monarchy that would then distribute out temporary uses of their land to this idea of heritability, where we would pass down title to land or property from one generation to the next. And then you could then sell rights into that title or buy rights to other people's title and stuff like that. And the king no longer owned everything, but he owned everything and was able to actually grant title to people that had permanency to it. So most of our property stuff is done through common law. And along with common law property claims, we have common law torts, personal injury type claims as well. So there is a common law harassment that developed, but no states, to my knowledge, recognize a common law harassment. So any harassment claim is going to be brought under statute. And so the statutes are going to have specific parameters by which one would prove harassment. So when you hear people talking about harassment as a legal claim, you can simply pull up whatever state either the harassment is taking place in. So the state that the harasser is in, the state that the harassed is in. You can look up the law on that, and you can determine if the harassment meets the requirements of the statute itself. So, yes, Dax, we do also have maritime law. But harassment claims are judged by statute. So basically, if the statute is clear enough, if it's valid and not void for vagueness or overbreath, then you've got a valid harassment statute, and you can just weigh out what level of harassment you're at. So I don't have a case on that because you'd have effectively like 50 different cases. So we're going to move on to defamation. And this is kind of a common theme lately. Like, what is defamation? Who is being defamed? Who can be defamed? Who can't be? Where does speech transcend from just words into defamation and stuff like that? So I brought up a pretty popular case that a lot of people talk about. I'm not sure if they're familiar with it, and its procedural history is really complex. not really complex, but it's pretty complex. So this is Jesse Ventura versus Chris Kyle. If you know, Chris Kyle is the American sniper. He is I think the most decorated sniper in American history, allegedly the most effective sniper in American history, and wrote the book American Sniper, talking about some of his exploits as a Navy SEAL sniper. Okay, and of course he was murdered by a veteran who he was attempting to help at a gun range in the least suspicious thing possible. If you're into conspiracy, there's a good one, of course. But yeah, so he was murdered, unfortunately, right shortly after his book came out. And so Jesse Ventura, being the stand-up citizen that he is, sued the estate of Chris Kyle, the American sniper. And that's kind of the start of it. And let's look at the background. I'm not going to read this whole decision. So, importantly, this decision that I have here... oh, wait a minute. Did I pull the... Okay. So this is a memorandum opinion and order. This is not the final outcome of the case, and this is not the appeals case. This is an order in the middle of the case. And this was a motion for summary judgment, or judgment as a matter of law. I don't quite remember, but I'm going to get into it. And Sean Thompson, yes, I have heard quite a bit of that. Absolutely. Some appears to be some claims that Chris Kyle was not the most honest dude, and that is fine. Absolutely. His credibility has diminished since his passing. Apparently, everyone was afraid to attack his credibility while he was still alive because he could kill them from miles away. It's a joke. It's a joke. It's a joke. Anyway, so, but Jesse Ventura holds a special place in Minnesota, of course, as the former governor here. So this puts him into an interesting sort of category. But let's talk about this. Okay, I'm not going to read the introduction because I just introduced it in my own way. But here's the background. Jesse Ventura is a well-known former wrestler, actor, and governor of Minnesota who served as a member of the Navy SEAL Special Forces underwater demolitions / SEAL teams during the Vietnam War. Chris Kyle was a Navy SEAL sniper and author of an autobiography entitled American Sniper, the Autobiography of the Most Lethal Sniper in U.S. Military History, which is a little wordy. I think his editor should have fixed that. The book, which was released January 3rd, 2012, reached a #1 on the New York Times bestseller list by January 29th, 2012. And in June 2012, Warner Brothers purchased the rights to a film adaptation. In American Sniper, oh, look at that PDF. I assume you guys can see that. SYIIPER. So good job, legal. having a PDF reader that is effective. In American Sniper, Kyle wrote a subchapter captioned "Punching Out Scruff Face" about an alleged altercation with Ventura. According to Kyle, the encounter took place at McPee's, a bar in Coronado, California, on October 12th, 2006, during a wake for Kyle's comrade, Mike Monsoor. And we don't use comrade in America, Judge. Maybe you should have gotten the memo. Who was killed in the line of duty. The subchapter reads as follows. After the funeral, we went to a local bar for the wake proper. As always, there were a bunch of different things going on at our favorite night spot, including a small party for some older SEALs and UDT members who were celebrating the anniversary of their graduation. Among them was a celebrity I'll call Scruff Face. Scruff served in the military. Most people seem to believe he was a SEAL. As far as I know, he was in the service during the Vietnam conflict, but not actually in the war. I was sitting there with Ryan and told him that Scruff was holding court with some of his buddies. I'd really like to meet him, Ryan said. Sure. I got up and went over to Scruff and introduced myself. Mr. Scruffface, I have a young SEAL over here who's just come back from Iraq. He's been injured, but he'd really like to meet you. Well, Scruff kind of blew us off. Still, Ryan really wanted to meet him, so I brought him over. Scruff acted like he couldn't be bothered. All right. We went back to our side of the bar and had a few more drinks. In the meantime, Scruff started running his mouth about the war and everything and anything he could connect to it. President Bush was an a-hole. We were only there because Bush wanted to show up his father. We were doing the wrong thing, killing men and women and children and murdering. And guys, do you believe that Jesse Ventura did not say that? Because I don't believe he did not say that. I 100% believe that Jesse Ventura said those things. Okay? And on and on. Scruff said he hates America, and that's why he moved to Baja California. 9/11 was a conspiracy, and on some more. The guys were getting upset. Finally, I went over and tried to get him to cool it. We're all here in mourning. I told him, can you just cool it, keep it down? You deserve to lose a few, he told me. Then he bowed up as if to belt me. I was uncharacteristically level-headed at that moment. Look, I told him, why don't we just step away from each other and go on our way? Scruff bowed up again. This time he swung. Being level-headed and calm can only last only so long. I laid him out. Tables flew, stuff happened. Scruff face ended up on the floor. Heft. Quickly. Heft? I think it's supposed to be I left. Good job. Good job, legal. I left quickly. I have no way of knowing for sure, but rumor has it he showed up at BUD/S graduation with a black eye. All right, so that's the end of the quote from American Sniper. Although he does not name Ventura in print, Kyle has confirmed in television, radio, and print interviews that Scruffface is Ventura. In early January 2012, Kyle appeared on the Opie and Anthony Shoiv, a talk radio program, and the O'Reilly Factor, a talk show, retelling the above-quoted story about Ventura and repeating Ventura's alleged statement, you deserve to lose a few guys. The story also appeared on Fox News. Kyle maintained that, quote, the events that happened in the book are true, and that the essence of what was said is accurate. He testified in his deposition that he was standing on the sidewalk outside the bar with 4 or 5 people around, and Ventura was talking loudly about how he disagreed with President Bush, the Iraq War, and the SEALs' tactics. Ventura told him they deserved to lose a few and took on an aggressive posture. At this point, he thought Ventura might hit him, so he punched Ventura in the face, knocking him to the ground, and then turned and ran down the street toward Danny's, another SEAL bar nearby where Kyle and others continued to drink after McPee's that night. Kyle could identify only one witness who heard Ventura say, you deserve to lose a few, and saw him punch Ventura, Jeremiah Dinnell. Dinnell testified that he saw Kyle and Ventura arguing on the patio, heard Ventura say that with what they are doing overseas, they deserve to lose a few guys, and then saw Kyle punch him in the face underneath the eye. Dinnell could not recall if or how Ventura fell after the punch or whether there was any blood. Dinnell did not see where Kyle went afterward, but Dinnell took off toward Danny's. Laura DeShazo also stated that she saw an unidentified male hit Ventura at McPee's that night, and several witnesses testified to seeing Ventura getting up from the ground and Kyle leaving. Still others who were at... Man, look at the typos in this. Can you guys see these typos? Who were at McPee's did not witness any altercation, but testified to hearing about it from Kyle or other SEALs later that night at Danny's or at breakfast the following morning. Although Dinnell was the only one who allegedly heard Ventura say the SEALs deserve to lose a few, several of Kyle's witnesses testified to hearing Ventura express disagreement with President Bush, the Iraq War, and the SEALs' tactics. Guys, this is not out of character for Jesse Ventura until it started to damage him economically. Yeah, I know the font size is really small, and I'm sorry. If I make it bigger, it's just going to be a mess. But I'm not going to read this whole conversation. Okay, so that's the background. So here's, if you're not familiar with what happened in the case, all right, let me give you the procedural history. So this was brought in Minnesota district court, federal district court, but in Minnesota under Minnesota laws for defamation. Okay. And they made all of their arguments. They brought all of their witnesses. Again, this is before any of that happens. This is this has got to be... Okay, this is a motion for summary judgment, and I'll talk about that in just a second and what that actually means, because it might be important to some of the other cases we're watching. But let me just say what happened. So this motion was denied for summary judgment, so this had to go to jury trial. The jury gets all of the evidence, hears from all of the witnesses and from the testimony of Ventura, and of course Kyle, being dead, cannot defend himself. or cannot advocate on his behalf. So they have to rely on the statements of everybody else. So then the jury gets into the deliberation room and they decide in an 8-2 verdict because they could not get a unanimous verdict. They decide in an 8-2 verdict to find in favor of Jesse Ventura. And he's awarded $500,000 for damages and an additional $1.35 million in unjust enrichment claims that he says, that the Kyle estate was unjustly enriched by defaming him and using his name and persona. That gets appealed, and on appeal, the Kyle estate argues that the Ventura's lawyers impermissibly raised the issue of insurance on behalf of HarperCollins. HarperCollins is a publisher of the book. They say that when they raised insurance outside of the rules of evidence, that it tainted the jury's ability to make a decision because the estate of Chris Kyle wasn't going to pay for this. The insurance company for HarperCollins was, allegedly, based on the statements that they made. That's the reasonable inference that the jury could conclude or could come to. So when the jury hears that we're not going to hurt the dead man and we're not going to hurt the widow of the dead man, we're going to just take money from an insurance company and give it to someone who received the wrong thing, that potentially changes how the jury would decide. So the decision in favor of Jesse Ventura has been overruled by the appeals court on the grounds that the raising of the insurance was impermissible. So Jesse Ventura does not get any money. He applied for certiorari. I don't even know how to pronounce that. Anyway, he applied to the Supreme Court for an appeal, and the Supreme Court denied it. Therefore, the decision of the lower court, the appellate court, stands, and Jesse Ventura does not have any money. The case has been remanded to the lower court, which means the lower court gets to act on the advice of the appeals court, which means that Jesse Ventura doesn't get any money. Okay, so he could, in theory, move for a retrial or something like that, but at this time, he has not won, and the Kyle estate does not owe him any money, nor does any potential insurer. So, good news for Kyle, bad news for the body. Now, as I stated, this was a motion for summary judgment. It's important to know that, to know why this wasn't a thing, because this is a weird case for defamation. Okay, because it ended up going to a jury to decide the defamation. We'll talk about that in a minute. A motion for summary judgment, which we may see in some of the other cases that we're following on this channel. We're going to talk about why have juries in just a second. A motion for summary judgment is a motion to say that everything that has been said in this case that matters, the parties agree. The parties agree on all of the facts, and then now we want you to rule on the law underlying those facts. So then a court, when they're deciding to rule in summary judgment, in this case, the estate moved for summary judgment. So the court's going to determine if the estate should just win automatically based on what's been said. So then it's the plaintiff's job, or in this case, Jesse Ventura's job, to raise what's called a genuine issue of material fact. And that's where there's a factual issue that we disagree on with the other party that a jury has to conclude, or a judge, if you're doing a bench trial, but in this case, a jury will have to conclude what the truth is of this situation, because without resolving this disagreement, we can't resolve the underlying legal issue. So to answer your question as to why have juries, then the jury is the arbiter of the facts in this case. The problem is not that the jury reached the wrong legal decision necessarily. The problem is that the plaintiff's attorneys broke the rules of evidence in raising the issue of insurance and tainted the ability for the jury to make an impartial decision. Okay, so that's that's how we get to there. But I apologize because I know summary judgment gets to be really heady and really kind of deep down the legal wormhole. But I wanted to let you guys know what it is so that you have the proper procedural basis. But now we're going to move into the defamation claim here. And this is relevant because Jesse Ventura is agreed by both parties to be what's called a public figure. Now, if you follow me on Twitter, there's some people who do not understand what public figure status is. So we're going to talk about that a little bit. But when you're a public figure, you have a reduced level of protection for defamation claims because people can make opinions about public figures, and public figures are said to have the type of platform that would allow them to combat this sort of defamation claim. Now, who is a public figure is always interesting. In this case, both parties agree that Ventura is a public figure. So Ventura didn't even try to argue it. But here we go. So let's get into the analysis for defamation, because this will talk about that a little bit. Where the plaintiff is a public figure, which the parties agree Ventura is, a defamation claim requires 1, a false and defamatory statement about the plaintiff, 2, an unprivileged publication of that statement to a third party, so a publication without some sort of consent, or 3, a tendency to harm the plaintiff's reputation in the community, and 4, the defendant acted with, quote, actual malice. Let's see if it says the burden is on the plaintiff to prove each of these elements. Here, defendant disputes whether Kyle's statements were false and whether he acted with actual malice. The defendant, of course, sorry, I just read Biggest Dickhead's quote, and I'm not entirely sure what it means, but it's funny anyway. So actual malice is knowledge of falsity. So if you get something wrong and end up making a false statement about someone, that's not malicious. You're just wrong. But if you are acting with actual malice, you know the statement is false, and you proceed to do it for the purposes of damaging the other person's reputation or causing them some sort of harm. So that's the public figure extra step, is proving actual malice. So let's see. In this case, let's talk real quick about what a public figure is, because some people seem to be confused about that. Thank you, Beverly. I get my hair cut at Universal Cuts in Wilmer. My dude Adrian does a great job. So if you're ever in Wilmer, Minnesota, definitely check him out. He's a great guy and he's hilarious. Who is a public figure is an important question in some of these cases, because if you're the recipient of the defamation, you don't want to be a public figure. Then you get more protection. Typically, there would be an argument over who is a public figure and who is not. In this case, Jesse Ventura is a public figure. He's a movie star, but most importantly, Jesse Ventura was the governor of Minnesota. Typically, anyone who is a major politician, so outside of a city sort of appointment, if you've got a national House member, a national senator, a governor of a state, they're going to be a public figure. And the public is going to have tons of criticisms of them, right? Because if you're ideologically opposed to them, you obviously want to criticize just about everything they do. So Jesse Ventura, being a former governor, is absolutely a public figure. If he were not a governor, he would arguably not be a public figure, because the status of his celebrity has diminished significantly since the days of Predator and WWF wrestling. Or was he WCW? Any of you wrestling fans know the status of Jesse the Body Ventura or his affiliation? Please drop it in the chat. I don't remember specifically, but his movies that he's in as the star are minimal. The most popular movie that he's in is probably Predator, and he had a smaller role in Predator, although a funny one. So Jesse the Body Ventura's status as a public figure would certainly be in question were he not governor. But if you're a governor, even a former governor, you're probably a public figure, unless we're talking 30 years removed from a governorship. then maybe you're not. But even so, man, you probably are. But public, in legal terms, public tends to mean public versus private. Agency of government is public. Okay, so government action is a public action. Government companies are publicly held, public companies. Public employees union would be state employees or federal employees, stuff like that. That's the public that is used in defamation as an automatic entrance. The other standard is pervasively, with pervasive notoriety, we'll say. So Beyonce, Taylor Swift, people who are identified by a large segment of the population, no matter where you go, they have pervasive notoriety and are public figures in that respect. But the actual level of celebrity to achieve pervasive notoriety is high. And I want to be very clear on that because people seem to misunderstand it because they're trying to use a common definition of public rather than a legal definition of public. And this is where a lot of people get hung up and why law degrees kind of matter. And believe me, I don't want to inflate a law degree. Go to law school and you will quickly lose any disillusion over the fact that that lawyers have some sort of special talent or brilliance. They don't. They don't. Let me dispel that. They're just people. Just people. A lot of them are dummies. In a lot of respects, I probably am too. So don't like put lawyers or any graduate degree on a pedestal. They're good at something and they studied something a lot. That's about it. They don't have any other special dispensation. So, but we have studied what public figure doctrine is in defamation claims. And so you should maybe listen to us when we talk about it. You know who you are. You can keep arguing with me all you want and I'll still end up being correct and you still won't. But that's okay. So in this case, Jesse Ventura has to prove material falsity. So where the falsity comes in is actually, it's not in what he said because Jesse Ventura actually admits later. I don't think he does it here. I don't think it's in this one, but it's later where Ventura admits that he has made statements consistent with some of the alleged statements, not the statement about Marines deserving to lose a few, or Navy SEALs deserving to lose a few, but statements about the conspiracy and Bush being a warmonger and the military being run by Christian extremists and stuff like that. He admits to making statements similar to that, and so those are kind of reasonable. What he disagrees with here is actually the punch and the knockdown. So he says that he was not punched and knocked down. That's the defamation claim here, is that Kyle says that he knocked down Jesse Ventura, and Ventura says, we didn't have a fight, he didn't knock me down, none of that happened. So there you go. That's what defamation looks like. If you guys have any questions about defamation, drop them here. I'm going to start to move on in just a second. I'm going to wait for the delay to see if any questions come about. But I don't want to get like super into the weeds on the Ventura case because ultimately he lost, but it's not because the statements weren't found to be defamatory. It's because they don't know if the statements are defamatory because the jury was tainted. And in theory, they could do a retrial. I don't think Jesse's going to. One, because it will only hurt his brand. I think it will hurt his brand rather than help it. This is my opinion. And two, because I don't think he will win without being able to raise the insurance issue. I don't think so. How do you prove malice? It's a tough thing to do. It's a really tough thing to prove malice. You have to show that someone's acting with knowing falsehood. So in this case, how you prove malice is by showing that the events didn't happen. And in this, what Ventura does is he brought some witnesses who said it didn't happen. If you really delve into this, there are real credibility problems with those witnesses. For example, they're talking about the next day, and the court apologizes for them referring to the next day and says, well, what they meant was the actual day. Even though they talked about October 13th, they meant October 12th. That's what they meant. And we know that because we know. So there's credibility problems there. Also, none of those people can assert that they were with Jesse Ventura the entire night. But, you know, it's all about in court who is credible to a jury. So in this case, what he would have to do is prove that he was not punched, basically, or prove that any of that might damage his reputation was untrue. And you do that through witness testimony or video. Video would help in some cases. If a person prank calls someone from state A to someone in state B and has violated harassment laws in both states, where is that person tried, at origin or at place of effect? They can be tried probably in the caller. Typically, the trial would occur in the state where the damage occurs. So typically in the recipient state. But if you're calling from state A to state B, you may be in violation of federal law. You may have a diversity jurisdiction claim, and it might be in federal court, in which case you could probably bring it in either forum, but they're likely going to bring it in the plaintiff's forum in that case, the person who was damaged. So I hope that helps answer that question. All right. So I am going to move on from Jesse Ventura because we've spent a lot of time on it, and I want to get into the Allison Mack stuff. But first, let's talk about stalking. So there are all sorts of crimes where words can hurt people: stalking, harassment, defamation. We've covered harassment and defamation. Moving on to stalking. So this is a case, USA versus Sean Sayer. And I picked this case. Can I sue an entire religion for hosting a party in which they're playing drums offbeat at 1:45? Yes. Reku3220 says, got a new, better paying job. Have a drink on me. I'm empty, so I will refill. Thank you, buddy. And congratulations on your new job. I hope it works out well for you. Guys, what am I going to go with here? I'm going to go with the rye whiskey. It's Richmond Rye from, this is from Border, I think, Distillery. Is that right? 45th Parallel. Wow. 45th Parallel Distillery in Wisconsin. And I've had this bottle for a while. I had 3 of their bottles. The rye is the most recent, and it is really good stuff. So if you're ever in Wisconsin, grab yourself some 45th Parallel because they make a good product. So D. Dotson 45 says, Ron Jeremy, public figure with huge privates or private figure with public privates? That's a good question. So that raises an interesting question, right? Like, where does public figure doctrine fall for something like a porn star who might be pervasively famous in a niche industry? Because, you know, a lot of people, depending on who's around them when you ask, may not want to admit that they recognize a certain porn star, okay? For various reasons. Like if you're in their church Bible study, that's like the meme, right, of embarrassment is you're in the church Bible study and you see some speaker and you're like, I recognize that person from somewhere. And then the little caption comes up and it's like, former porn star so-and-so. That could be pretty embarrassing. But Ron Jeremy is one of the probably few names who I would say automatically transcend the niche or the porn industry into the public sort of figure area, because, you know, he's publicly known. He's transcended porn and has done cameos in several other movies. He's a speaker in various places. The other people like that might be Stormy Daniels. Now, of course, would be a public figure. She is now in the public light, and due to her own actions, even though she's a former porn star, prior to all the news, she might not have been a public figure. Jenna Jameson is probably one who has transcended into the public sphere. So that Matt Holmes. Anyway, he's a very famous porn star from like the 70s, and has probably transcended into that, or at least for a time had transcended beyond that. But outside of that, you know, I don't know that many other porn stars actually receive the level of notoriety to be a public figure. So kind of, I don't know, just an interesting thought exercise for me. So Lucifer Love Monkey says, is a group of comic shops colluding to keep a book out of shops in any way illegal? What would it take to be illegal? See diversity in comics. And Lucifer, that is a great question. And unfortunately, thank you very much for the super chat. I have to do the irritating thing and say I cannot answer it right now because I don't know enough about diversity in comics, but I have been tweeted at by several people about the diversity in comics thing. One guy is particularly ardent and helping me trying to get into the case. I'm certainly interested, and I am hoping to do some research on that, come up with a good answer for you. And if all things work out, if anybody knows diversity in comics, at some point, I would love to interview him on this topic and talk about the legal issues around it, and you know, maybe see if he's considering getting legal help somewhere to do this, because my gut tells me that there's a problem here, but my gut also tells me that proving collusion is a difficult thing, and alleging collusion, you have to tread very carefully because you have to actually show some facts. You can't just say they colluded. You have to be able to produce some sort of documentation or dates or times, allege something that can be discovered and shown to the court. And I think in this case, there is an allegation. There are recorded conversations between comic shop owners. So it's interesting. So if anyone knows diversity in comics or has access to him, let him know that I am certainly interested in his case, and I will be reaching out to him for an interview, but I want to do some research on the case first. And because I love comic books in the sense that I think comics are cool and everything, and I like to read them on occasion, but I'm not going to claim to be versed in them or a fan or know anything about the industry or the culture around them. So I'm certainly interested, but a lot of you guys probably know more than me. So if you want to send me some DMs or personal messages about it, so you can point me to some places to read and research, I would love to formulate a much better answer, do a video on it, and also have Diversity in Comics maybe interview with me at some point and really hammer on this issue, because I do not like people being pushed out of the market by gatekeepers. Not a cool thing, in my opinion, especially if the gatekeepers' reasons for pushing them out are because of speech that they disagree with. But, I will work on that. Larry Bernard, and one of those guys was me. Good. Thanks, buddy. So yeah, stay tuned. Stay tuned. I will hopefully be doing at least one video on diversity in comics, and hopefully an interview with him at some point, and we'll talk about that. But yeah, thank you very much for the question. So let's get into the USAV Sayer thing that I started like 10 minutes ago. I love the chaos of these streams, guys. It's a lot of fun for me. I hope it's fun for you guys too. So this is an appeals case. This is a criminal case in which involves criminal stalking. In this particular case, cyber stalking. And I thought this was relevant because, one, cyber stalking seems to be involved in some of the other, like the Dick Masterson case, right? Potentially, Maddox could claim that Dick is stalking him, or Dick and Asterios and other parties might claim that Maddox is stalking them, or I could potentially claim that people are cyber stalking me due to some things that have happened to me. So let's look at what this looks like, what cyber stalking looks like. And the reason I picked this case, one is because cyber stalking, two is because it shows kind of like what type of acts get to the criminality part and get beyond just people arguing on the internet. Okay. So this case challenges the constitutionality of the cyberstalking statute, 18 USC Section 2261A. So this is a federal cyber stalking statute. And if it's federal, it tends to mean that you have to cross state lines with your actions. And this case does cross state lines. Factual background. I'm not going to read the whole thing on the introduction. Factual background. The facts are not disputed on appeal. So these are the facts of the underlying case. As the parties appealed, they agree that the factual basis for the case is correct. And just remember that when the defendant has agreed that this is what he did, because it's pretty good. Okay. Sayer and the victim in this case, Jane Doe, had dated in Maine starting sometime in 2004 until Jane Doe ended their relationship in January 2006. After their breakup, Sayer persistently stalked and harassed Jane Doe for over 4 years. Now, it's important to note that this is a common definition of harassment, and the common definition of harassment is used in the cyberstalking statute. It is not a legal definition of harassment. Oh, I didn't mention this, and bad on me. Bad on me for not mentioning this. But the legal definition of harassment, like I said, it varies state to state, but it tends to involve either actual physical harm or threats of physical harm or threats of economic loss, where a reasonable victim would conclude that they would potentially lose something of value or would be injured by what is going on. So, me bothering someone is harassing them. Like if you're following someone down the street going, hey, idiot, 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 that's annoying and harassing in the common sense. But that doesn't cause them actual harm or put them in fear. There would need to be something beyond that probably to put them in fear for their actual safety. And mainly because, you know, they could walk away or go into a building or go into a private area and get away from it, presumably. So stalking or harassment needs to involve that, typically speaking. But harassing is actually part of the stalking definition, the stalking statute, as the common harassment, common understanding of harassment would be, not the legal understanding. And we'll talk about that because this case talks specifically about harassing and what it means in the statute. But let's get to it. Okay, so after their breakup, Sayer persistently stalked and harassed Jane Doe for over 4 years. At first, Sayer showed up at stores and other places where he knew that Jane Doe would be. In response, Jane Doe changed her routine and gave up activities she loved for fear of seeing Sayer. She also acquired a protection order against him in state court. And then, of course, they refer to the victim, in this case, as Jane Doe to preserve her privacy. Later, in the fall of 2008, Sayer started to use the internet to induce anonymous third parties to harass Jane Doe. Specifically, several unknown men came to Jane Doe's house in Maine one day in October 2008, claiming that they had met her online and were seeking, quote, sexual entertainment. Jane Doe was, quote, shocked and terrified by these dangerous-looking men and decided to stay with a friend because she no longer felt safe in her home. She later discovered an online ad in the, quote, casual encounters section of Craigslist, a classified advertisement website that had pictures of her in lingerie that Sayer had taken while they were dating. The ad gave detailed directions to her home and described a list of sexual acts she was supposedly willing to perform. Jane Doe did not place these ads, nor did she authorize Sayer to place them. So you're starting to see what rises to that level of stalking in this case anyway. The unwanted visits from men seeking sex persisted for 8 months until June 2009, when Jane Doe changed her name and moved her aunt's house in Louisiana to escape from Sayer and this harassment. Jane Doe began a new career and felt safe for a couple months until August 25th, 2009. When an unknown man showed up at her home in Louisiana and addressed her by her new name. Jane Doe said the hairs on her arms stood up, as she had not told anyone except for a neighbor and her parents that she was moving. The man said he had met her online and was seeking a sexual encounter, having seen pictures of her on an adult pornography site. Guys, don't. just don't. When Jane Doe later searched the internet, she found videos of herself and Sayer engaged in consensual sexual acts from when they were dating on at least 3 pornography sites. Several of the websites included Jane Doe's name and then current Louisiana address. One site encouraged viewers to write to Jane Doe and tell her what they thought of her videos. Jane Doe contacted the police again in late September 2009 because someone had posted a fraudulent account in her name on Facebook, a social networking site which included sexually explicit pictures of her. The false Facebook account was created on August 21st, 2009 from 24 Marion Avenue in Biddeford, Maine, which had an unsecured wireless network. Sayer lived at 23 Marion Avenue. The police found videos of Jane Doe, quote, engaged in sexually explicit activity that had been posted to adult pornography sites in August 22nd, 25th, and 29th, 2009. Okay. It's almost like creating fake accounts of people to cause them harm or to damage their reputation might be cyber stalking in the eyes of the law. Might be. So a warning out there to people who are creating false accounts, if you know of anyone, with the intent to defraud people into thinking that you are the person you are fraudulently creating an account for. If you're doing that, you might be in violation of a cyber stalking statute, which is a felony. Federal felony, which means you could go to federal prison for doing so. So if there's anyone out there who may see this stream and may think like it would be a good idea to create a false account for someone else for the purpose of damaging them, harassing them, or causing them harm, I just want to warn you that that might be a felony. Tito. Okay. What about parody accounts? It really depends. That's a good question. But it really depends on what you're doing with that parody account. Parody is different from impersonation. If you're trying to be that person, like in this case, they created a fake Facebook account to be the woman, right? Shadecast. Thanks, Jason Benham. They created a Facebook account with the and Craigslist ads, right? Well, let's not ignore those. Pretending to be the person with the intent of causing her harm, and that harm comes in the not feeling safe, being constantly harassed or bothered outside of the normal social interactions, having advertising that people should write to her about sexually explicit things, should show up at her house. That really starts to transcend. A parody account that is obviously parody is not going to rise, likely not going to rise to the level of cyber stalking, because you're not trying to pass yourself off as that person and fool people into or induce them to committing certain acts that would cause the other person harm. Pizza Wolf says Maddox never tried to be a woman. What barometer is used to tell the difference between someone who is impersonating or emulating someone? I'll say it's a human barometer, so it really is going to depend on how good of an argument you can make. But I will say that right now on Twitter, there is a false Dick Masterson account, a false Dick Masterson Twitter account that uses Dick's Twitter picture and then goes out there making statements that look like they're aimed at causing damage to Dick Masterson or his brand. All right. We also know that false Twitter accounts were made for 80s Girl, which could have induced people to get similar to this, causing her to be sexually harassed, based on the actions of that account, and posted private information about her and stuff like that. So I'm just saying, if there's anybody out there, maybe on Twitter, creating false accounts to look like people, or maybe they did it on Tumblr before or something like that, and you're trying to damage someone's reputation, you might be committing a federal cyber stalking crime, especially if you're in a different state and the person resides. That's where it gets into federal, and that you don't want to be on the bad end of this statute. So just trying to help anyone out there, Tito, who might be doing this. Think about it. All right. Moving on. Jane Doe contacted the police again in late September 2009. Maybe they could claim it, but I think the hard thing in these types of cases is, and this is a criminal statute, right? So the government would have to be able to show the intent. So it's really going to look like, are they making statements that would be damaging? Are they inducing people to act negatively against the impersonated person? Making a joke on an impersonation account or on a parody account, it depends on if it's a parody, if it's obviously a parody. These are gray areas. So, if you're going to make a parody account about someone, make it a parody. Like, that there would not be confusion that this was the actual person. Okay? That's the best advice I can give you. All right. Late September 2009, because someone had posted a fraudulent account in her name on Facebook, social networking site, which included sexually explicit pictures of her. Oh, wait, I read that paragraph. I think if I reread a paragraph, you have to drink, so you better do that. Clay, where are you? All right. On November 5th, 2009, the police searched Sayer's home pursuant to a warrant. They found 2 desktop computers that lacked hard drives and an empty laptop computer case. Sayer said that his computers had been hacked, so he had thrown out the hard drives. I was hacked. He also said he had thrown out his laptop after spilling water on it. Police did not believe him because they had seen, quote, dozens of computer components scattered throughout his house. Police seized a Nikon digital camera during the search. Although Sayer had said there were no pictures of Jane Doe on it, a forensic analysis of the camera uncovered a picture of Jane Doe in a sexual position and another photo of her engaged in a sex act. In December 2009, Jane Doe again contacted the police to report another fake profile that had been created under her name on MySpace, another social networking site. The profile had both her old and new names, her Louisiana address, and links to adult pornography sites hosting sex videos of Jane Doe. The fake MySpace account was associated with multiple IP addresses from unsecured wireless networks in Saco, Maine, near where Sayer lived. A business with one of the unsecured networks had surveillance, which had captured an old green pickup truck resembling Sayer's green 1999 Ford truck parked outside for 20 minutes at about the same time that the fake MySpace account was being accessed. No one was seen getting into or out of the truck during the time that it was parked there. Jane Doe returned to Maine the first week in November 2009 because the men that Sayer sent to her Louisiana home had scared her aunt and her cousin, with whom she was staying. Cyberstalking charge in this case only encompasses Sayer's harassment of Jane Doe from July 2009, the exact date being unknown, until November 2009. However, Sayer continued to harass Jane Doe after she returned to Maine. As a result of new fraudulent accounts Sayer posted in Jane Doe's name, soliciting sex from strangers, as many as 6 different men per night showed up at her home in June 2010. So, again, federal law requires various things. It tends to be diversity jurisdiction to invoke a federal statute, not a state statute. And in this case, when she moves back to Maine in the same state as him, the federal courts probably don't have jurisdiction at that point. Police searched Sayer's home again on July 1st, 2010. Forensic analysis of a laptop computer they seized showed that Sayer had created numerous fake profiles through Yahoo Messenger, an online chat service using some variation of Jane Doe's name, between June and November 2009. And we now know that degenerates were still using Yahoo Messenger in 2009. All of the profiles had sexually suggestive or explicit pictures of Jane Doe, and in many cases directed viewers to sex videos of her on adult pornography sites. In many instances, Sayer, posing as Jane Doe, chatted with men online and encouraged them to visit Jane Doe at her home in Louisiana. Jane Doe said Sayer did not stop sending men to her home until he was arrested by state police in July 2010 for violating protection orders she had against him, too. For example, an ad that Sayer posted on Craigslist in January 2010 said Jane Doe was, quote, looking for only 5 guys to gangbang me. I will start hosting at 1:30 today. First 5 that come get to join in the fun. This will be fun. I will do anything. That ad included Jane Doe's name and current main address. Sarah also created a new false Facebook profile in Jane Doe's name with links to videos of her having sex as late as June 2010. That profile said, I'm always horny and entertaining. I like to sit out back and drink, so stop in and say hi. If I am not out, knock on my back window. I'll come out to play. Hee hee. Uh-oh. Might have been Maddox. I just love to F. In addition, 2 new MySpace profiles that Sarah had created in March 2010 gave directions to Jane Doe's home and invited both men and women to go there for sexual activity. Gats says, yo, Rackets, haven't been around in a bit. I heard you're part of the targeted harassment campaign now. Big foul, man. By the way, Allison Mack is legit 2 million? 200,000% hotter to me now. Ashley, big question here, but why though? I don't get why you would do any of this, right? Like trying to understand insane people is not a fruitful endeavor. Okay, so I'm going to stop with the back. That's the whole backstory. I wanted to give you guys an idea of what cyberstalking can look like and how that might relate to activity of people we may have encountered on the internet. You may have encountered, I may have encountered, all sorts of people encounter different people. But I'm going to skip down to the court's analysis of the cyberstalking statute because there's a specific line that I want to get to, okay? And again, I unfortunately had to use... since I had to use the actual thing, I don't have my Westlaw easy citation. First Amendment challenge. Okay. Okay. Almost there. So what about stands? What about stands, which was a term I learned from Peach Saliva? Oh man, I have no idea what you're talking about. Stands. Hold on. You can keep asking questions while I look for this specific line. I'll know it when I see it. Here we go. So I'll start at this argument. So Mechhead09, what is stands? What is stands? Pizza Wolf, I am coming through Dallas, but I'm not coming to Road Rage Dallas. If that makes sense. But I will be driving through Dallas, and I should have time to make a stop. If I started a sex cult, could I use your army of followers, which you use for targeted harassment campaign to recruit washed up celebrities? Yeah, sure. I want to know what your take on Repzilla's most recent video showing the deleted Reddit from Mariah's abuser. I haven't watched it yet, Demi. But DM me on Twitter or Facebook or something, and I'll watch it and we can talk about it. An overzealous or obsessive fan of a particular celebrity. Oh, okay. So a stan. I got it. Let's see. So what was your initial question? So what about stans? You know, it all depends on what their activity is. It really depends on what their activity is. There's no like celebrity exemption for stalking, cyber stalking, stuff like that. If you are putting someone in reasonable fear for their safety, stalking pretty often. Stalker plus fan. Got it. Has there been any precedent set about VPN usage? Could I get in trouble for saying something mean if my VPN is set to Scotland? You know, I don't know of anything, but that would be interesting. Like, what would be interesting, I assume you're referring to, like, the Count Dankula. So if you violated the Communication Act by using a VPN in Scotland, but you were in, like, America, which wouldn't normally find you, you know, guilty for some speech, but in Scotland they would. That's a really interesting question. I don't know if any court has a judge competent enough to make that answer. And thank you very much, Beverly. I really appreciate that. Super chat. Even though you didn't ask any question, I will thank you very much and take a sip of whiskey for that. Jason Benaim says, I think using a VPN would be like an enhancement thing because you're using a tool to not get caught. And that's interesting. That may be true, but it might also... The interesting thing is, if you're VPNing your communication through Scotland, you're literally making the communication in some respect from Scotland because you're routing the communication there using their network, and you may be subjecting yourself to their laws. So that's an interesting sort of question. I'll have to look and see if I can find any information about that because, man, I don't know. So, all right. Okay, check your Twitter DMs when you get the chance. I put the link to Repzilla's newest video, and I drank a nice glass of 99 proof speech schnapps for you. Awesome. Awesome, Demi. I will do that. I will do that. I suspect, look, the Poppy lawsuit has the recipe for a ridiculous amount of drama and intrigue. So I suspect we'll be covering it for a while. So, you know, set your calendars. It's going to be a long case unless things just get dismissed right away. And I will probably do some Poppy themed live streams. What I definitely want to do is when Poppy and Sinclair respond to sheets, I will be live stream reading the documents for anyone who's interested in the Poppy suit. So I'll tweet out about that and stuff. So if you're interested in Poppy, welcome to the channel. If that's brought you here, that is great. Definitely check out some of the other content, but know that, Poppy stuff, I think that case is going to explode in all sorts of bad ways. So I will be covering it pretty thoroughly. So definitely look out for that. And if you know people who are interested in that Poppy lawsuit, make sure and direct them to the live streams when those things come out, because if they want to ask questions, we'll be covering those pretty specifically. Poppy song sing along coming soon. No, I don't think so. All right. Okay. So let me get back to this because we're going to wrap up this Sayer case and then we're going to hit into Allison Mack's case and hopefully we'll be done in like 2 hours. So Sayer. And by the way, this is a personal shout out to Repzilla. Dude, I love you. You're hilarious. And I'm so glad we got to do a video together. I hope we get to do some more. One, because Socratic Truths hates it. and two, because you are so far outside of my normal YouTube consumption that the fact that this lawsuit has brought like you into my radar and me into yours is just cool. And I like it. And I think you're a pretty genuine guy. And I really enjoyed our conversation. So, Rep Squad, if you're out there, I appreciate you guys, watching the video from Repzilla, and certainly hope to do some more work with him because he's a fun guy, and I think we're like way on opposite ends of whatever spectrum is out there. But it's cool how the internet can bring people together like that. So, oh, and yes, lawsplaining, patreon.com/lawsplaining is my Patreon. Thank you, FuzzGotGames, for reminding me that. Andrew, I don't know when the next Google lawsuit doc is dropping because they're sealed, but I'm working on a connection to hopefully get my hands on some sealed documents in an absolutely legal way. If I can do that, I will report them to you guys, and we'll see that. Gats, don't underestimate me, buddy. I knew that pun was happening. Okay. So let's get back to the Sayer case real quick. Sayer argues that because so this is his First Amendment challenge to the cyber stalking statute. And I'll summarize the gist of his challenge. He says that it violates his First Amendment rights to free speech if he can't make ads to demand people go solicit sex from this woman, which is a bold strategy, Cotton. Let's see how it works out. Sayer argues that because the text of Section 2261A2A encompasses speech that causes only substantial emotional distress, it prescribes protected expression that is merely annoying or insulting. So what he's saying is that this statute is overbroad. It encompasses not just unprotected speech, but because of the way it's worded, it includes protected speech. And that's overbreadth. It's a recognized constitutional standard and a bar to unconstitutional laws. If they're overbroad, they can't be enacted because we cannot go around accidentally prosecuting people for unprotected speech, even though we kind of do this all the time. But the goal is to not prosecute people for protected speech, I should say, in the aim of going after unprotected speech. So he's saying that basically because it involves the word harassing, which just causes emotional distress, and these aren't specific legal standards, that that encompasses protected speech as well. Bookham Dano says, is it legal to change my name to Rick Rekieta and open a law office? Yes, you can be my partner. We'll be Rekieta and Rekieta Law, and I think we can do great things together. Okay, so let's get back to this. It prescribes protected expression that is merely annoying or insulting. His interpretation of Section 2261A2A is unconvincing because it takes the term substantial emotional distress wholly out of context. See U.S. v. Williams, which states that refusing to interpret words in statute in isolation because common sense counsels that a word is given more precise content by the neighboring words with which it is associated. Other circuits have rejected similar overbreadth claims. See Petrovic, concluding Section 2261A2A mostly applies to conduct not protected by the First Amendment. United States v. Boker, rejecting overbreadth challenge to the 2261A's prohibition on conduct that places a person in reasonable fear of death or serious bodily injury, which was vacated on other grounds. The interstate stalking statute, which prohibits a course of conduct done with, quote, intent to kill, injure, harass, or place under surveillance with intent to kill, injure, harass, or intimidate, or cause substantial emotional distress, clearly targets conduct performed with serious criminal intent, not just speech that happens to cause annoyance or insult. Not just speech that happens to cause annoyance or insult. Guys, we're into the point where the level of, I guess, criminality that has to take place, the level of speech that has to take place, it has to be geared towards causing damage to a person, putting them in fear of death or bodily injury, causing substantial emotional distress, which I've said it before and I'll say it again. If you want to allege emotional distress, you might want to see a therapist and verify that emotional distress. Get a record of it so you can prove it in court, rather than just saying, I was sad for a while. That doesn't work. Rather than just saying, I'm a bald Armenian and I didn't want to make my favorite soup because I was depressed. That's not substantial emotional distress. See a therapist. Prove it. Prove it. Okay. All right. So that's what I wanted to talk about on Sayer. I'm not going to go through the rest of it. The court says this guy's a scumbag and a criminal and he's guilty. Okay, that spoiler alert. They don't overturn the obvious criminal acts of this person. And just reading, sometimes when you read the factual status, and remember, this guy, the defendant, Sayer, did not dispute what happened. He made these accounts. He induced men to solicit his ex-girlfriend for sex. He posted her videos of his and her sexual encounters without her consent for the purpose of getting other men to bother her. He encouraged people to write her letters. He encouraged people to visit her at her home and at her second home. He gave people her changed name, all of that stuff. This guy is terrible. He's a terrible human being, right? This is the extreme of extremes. So, but I picked this case again because it does talk about creating fake social media accounts, which has been going on recently, and using those accounts to cause damage to someone. It doesn't have to be this drastic sexual damage. Causing economic harm or putting people in fear for their safety, those types of things, causing them substantial emotional distress through your criminal impersonation can be a felony, and it can be a federal felony, and you don't want to do that, Tito. Okay. So here I have a bunch of out of order documents for Allison Mack. If you guys have any questions about that Sayer case, or what is cyberstalking, or what is stalking, like, the reason I bring this up is this stems from the lawsuit, right? With Maddox. It stems from the lawsuit and his constant use and his recent interaction with a fan, talking about harassing people and stalking them. Any of these sort of legal terms that he throws out. Someone sending you something mean online once isn't harassment, and it isn't stalking. It may make you uncomfortable. It may be inappropriate. It may be really rude and terrible, and the person maybe shouldn't do it. All of those things can be true, and it doesn't rise to a legal issue. Just block them. Just block them. When people start showing up at your house, when they start creating accounts to get around the blocks, when they start bombarding you over and over, woman was just convicted for sending 65,000 text messages to a man she went on one date with. That's when you start to get into the level. Like, that's a bridge too far. I mean, obviously, even sending 3 text messages could be stalking and harassment if the person clearly communicates with you to stop. But one communication from someone that makes you feel bad or makes you feel like a giant cuck or whatever it is that you are, that's not stalking. And by the way, in case there was any confusion, making a video commenting on you that you don't have to watch, and me not sending it to you or somehow inducing people or encouraging people to go talk to you, because I will maintain, don't talk to Maddox. Don't talk to Landau. Don't talk to anybody from Madcast Media, ever. Don't even bother consuming their content, and certainly don't go out of your way to talk to them or send my stuff to them. I don't want anybody to talk to them, ever. I want them to fade away into obscurity where they belong. If I cannot be cyber stalking you, I cannot be harassing you, cannot be defaming you, as long as I'm telling the truth, as long as I'm not asking people to bother you, that's how it goes. So, are the videos still up asking for a friend? Just Steven Severin. I don't know. I don't know, and I don't know how to find out because I don't know the woman's name. It was referred to as Jane Doe. What is the typical prison sentence for cyber stalking according to the federal statute anyway? That is a good question. And let me it's 18 USC. I don't have that actually pulled up. Is it 2261A? Here we go. She'll be punished as provided in this title. Okay. All right. That was a great question. And the answers vary. So let me talk about the prison sentence real quick. So, a person who violates this section or section 2261A shall be fined under this title, imprisoned for life or any term of years if death of the victim results. So if you induce people to show up, like if someone showed up to this woman's house and murdered her, you could get life in prison. For not more than 20 years if permanent disfigurement or life-threatening body injury to the victim results. Permanent disfigurement, in legal terms, by the way, is a scar that is permanent. So if you cause a wound, or if someone causes a wound that needs stitching, stitches as a result of something like this, that's a permanent scar, and that is a permanent disfigurement under the law. So you could get 20 years for not more than 10 years if serious bodily injury to the victim results, or if the offender uses a dangerous weapon during the offense. So that could be something like a broken arm, something non-life-threatening but damaging. A severe cut that needs hospital care would be a serious bodily injury. As provided for the applicable conduct under Chapter 109A, if the offense would constitute... Okay, so this is 109A, blah, blah. Not more than 5 years in any other case, or both fined and imprisoned. Whoever commits the crime of stalking in violation of a temporary or permanent civil or criminal injunction, restraining order, no contact order, shall be punished by imprisonment for not less than 1 year. So the answer to your question, the ultimate answer to your question is, in this case, 5 years. No substantial bodily injury occurred to the woman as far as I know. So 5 years is up to 5 years is his federal prison sentence. If she had been injured, 10 years. Permanent disfigurement or life-threatening bodily injury. A concussion can be a life-threatening bodily injury, a head wound of any kind, or any wound that puts someone into critical or serious condition at a hospital could be a life-threatening bodily injury. Those would be 20 years. And then if the person dies, life in prison. Okay. So there we go. There we go. All right, let's move on to Allison Mack's case. And, oh my goodness. Where should we start? Let's start with the indictment. This is the most important document, probably. This is a grand jury indictment of Allison Mack and Keith Raniere, also known as Vanguard. And guys, if you're picking a sex cult leader name, Vanguard sucks. You should have a much better name than Vanguard, and you can consult any D&D player to come up with a cooler name than Vanguard. Come on. Come on, Keith. Get with the program. Madcucks, you report my stream, buddy, and I will fist fight you in the streets of Oklahoma. I'm reporting this stream. This is specifically harassment and defamation. Hey, buddy, welcome to the stream. And happy birthday, by the way. Happy birthday to Madcucks. If you're in the stream and you care, send Madcucks a happy birthday request. And because he's a good dude. It was his birthday the other day. I don't remember specifically. Was it Tuesday? Was it Tuesday or Monday? No one else has the guts to come down here. Dude, no one wants to go to Oklahoma. Because, listen, I drive through Oklahoma all the time on my way to Texas. And every time I stop in Oklahoma, it's hotter in Oklahoma than it is in Texas. And that is terrible. I remember last year we drove through, and I apologize, guys. This is a little derailment from the stream, but Madcuck showed up, so gotta have some chatter on that. But we stopped at a rest stop in Oklahoma, and my kid gets out of the car, my 10-year-old. I guess he was 9 at the time, and he's like, "Dad, what is happening with this weather? It's so hot. It's so hot." And I'm like, "Well, buddy, we got to go to the bathroom." He's like, I can't make it. I can't make it to the rest stop." We drive through, I think, Tulsa normally. No, we drive through Oklahoma City because we always drive through Norman and Moore and all that stuff. Because I've been noting over the years the tornado, the Moore tornado that came through. I always note the path of it because we drive right down 35 on that path. Okay, so let's see. Yeah, their rest stops are garbage. Absolutely. Hey, Norman's okay because you got the college there, and they have some decent restaurants and stuff. I think we've stopped at that Hampton Inn a couple times. Anyway. All right, let's talk this indictment. So, again, thanks, Madcucks. We're gonna start talking about Allison Mack Allison Mack, if you don't know, is a former television star of co-star of the show Smallville. And if you don't know who she is, just a second. Let me see what we got. Look at that. Back when people used to buy DVDs. Allison Mack is this chick right here. You can kind of see her. So, usually you can see her smiling with a bunch of teeth because she has a wide smile. Although, allegedly, the gum to teeth ratio on Allison Mack is off, indicating that she is definitely a sexual predator. And you can ask my doctor, Matt Reifler, about that. Or you can join Teeth Posting, my new favorite Facebook group. Gatsgat says, "Hey, Rackets, just wanted to thank you for private video you sent the real high patrons. I want you to know that I followed all the instructions and you know who should be getting the anthrax soon." That is Gats. Don't you dare. That's not Allison Mack? Are you sure? Oh, no. I think you're right. Hold on. Let me see. I've got Allison Mack pictured in here. Oh, I'm sorry. That's Allison Mack. I went with blonde and on the cover, but that wasn't her. You're right. That's Allison Mack, this chick right here. Guys, this is the irresponsible drinking that Lagavulin was talking about. I can no longer properly identify C-list celebrities. All right. Okay, so this is her grand jury indictment. And if you don't know how that works, federal crimes for high crimes tend to involve a grand jury where they bring in a bunch of jurors and then a prosecutor gets to make the case that they have probable cause to bring charges against someone. Grand juries are largely a sham, in my opinion, because you don't really tend to get a defense in a grand jury because it's not about whether you're guilty or innocent. It's whether the prosecution has enough evidence to bring the charge in the first place. So this grand jury has decided that Keith Raniere and Allison Mack are in deservedment of indictment in federal court, and so that this trial can continue. Also call her by her proper name, Mistress Demon, Mrs. Gats. All right, so I'm gonna read through this. This is 5 pages, and let's just go through. And guys, just so you know, I tried to get the transcripts, and let me check my email and make sure I haven't gotten them yet. But I did actually request the transcripts of the hearing for... Oh, dude. Ah, dang it. Okay, guys. I will have the transcripts, the unredacted transcripts, because it's prior to the redacting documents. But it is $20 to get the transcript. I was not able to get them before the stream today, so I will get them. I will get them and we'll cover them if they're interesting. So yeah, I tried to get the actual transcripts of the only hearing they've had in this case to see what's happening, and I will real-time disappointment. What is Scanlon MJ? I have no idea. Probably a magistrate judge. Let's see. So Jason Benham says, okay. Anyway, we will be getting these, getting this transcript, and I will cover it. And yes, I am in before the redaction period, so it will be unredacted. It hopefully will have something juicy in it, but who knows? And I'll try following this case as well. But just so you guys know, there are real costs involved in some of these documents. But I'm willing to undertake that for you, the fans, and also for my own entertainment. Gatscat says, guys, I'm legit in love with Allison Mack. Any disparaging remarks will be considered harassment and stalking. This includes you as well. Hey, I will not be disparaging anybody here. Allison Mack, for the record, and we'll cover this in the documents, has pled not guilty to all counts. So remember that this is the government making these claims, and the government is wrong all the time in criminal cases. And never trust them. So count 1. This is what the grand jury has charged. Sex trafficking on Jane Does 1 and 2. In or about and between, it's a lot of qualifiers, February 2016 and June 2017, both dates being approximate and inclusive, within the Eastern District of New York and elsewhere, the defendants Keith Raniere, also known as Vanguard, and Allison Mack, together with others, did knowingly and intentionally 1. Recruit, entice, harbor, transport, provide, obtain, advertise, maintain, patronize, and solicit one or more persons, to wit, Jane Does 1 and 2, individuals whose identities are known to the grand jury, in and affecting interstate and foreign commerce, and attempt to do the same. That's an ugly sentence. Meket, that's a big question. I have not found a case where the fans attacking someone without direct direction, we'll say, from a personality has risen to liability. I'm not saying they're not out there. I haven't found it. There are 50 states and millions of cases to go through. Yes, they do, Clay. Are there videos of this evidence for research? I mean, I kind of hope she goes to jail. I heard she's into handcuffs and bars. Okay, guys, come on. You're distracting me. Stop being funny. Okay, so basically all of these things, all of these verbs are possible under the statute. And then they either did this or attempted to do it affecting interstate commerce. Because if you provide prostitution in one state, someone may not have to buy it from another state. And if you know anything about this channel, under the Commerce Clause, Congress has just taken the authority to do whatever they want, including your right to not participate in commerce is included in participation in commerce. Good job, Wickard v. Filburn. Good job, Supreme Court being idiots. All right, so 2, benefit and attempt to benefit financially and by receiving a thing of value from participation in a venture which had engaged in such acts, knowing that the means of force, threats of force, fraud and coercion, and a combination of such means would be used to cause such persons to engage in one or more commercial sex acts. Guys, let's put this in English. They either fraudulently, coercively, or violently forced women or men to commit commercial sex acts. They force someone into commercial sexual activity that is in violation of the statute. That's the basic gist of these claims. Gotta run, catch the rest later. Call her Mrs. Gatz. I'll call her Miss Gatz for you from now on, buddy. Have a good night. Let's see. Count 2, sex trafficking conspiracy. In or about and between February 2016, June 2017, both dates being approximate and inclusive within the Eastern District of New York and elsewhere, the defendants Keith Raniere, also known as Vanguard, and Allison Mack, together with others, did knowingly and intentionally conspire to 1, recruit, entice, harbor. So this is the same crime, but it's the conspiracy to do so. So 2 people discussing something that is a criminal act is a criminal conspiracy, and as long as they're doing it with the intent to commit the act. There you go. That's criminal conspiracy, so it's kind of an add-on, an and one if you leave. Rekieta Law or Clay Early, if I only feel comfortable while wearing my headphones, am I on autism? Yes. No, you're that guy from Something About Mary, right? Her brother? That's you. Punch Brett Favre in the face or whatever. Count 3, it was Matt Dillon, right? Who got punched in the face? Count 3, conspiracy to commit forced labor, Jane Doe number 1. In or about and between February 2016, June 2017, both dates being approximate and inclusive, Keith Rainier, known as Vanguard, and Allison Mack, together with others, did knowingly and intentionally conspire to provide and obtain the labor and services of a person, to wit, Jane Doe 1, by means of serious harm and threats of serious harm to her and one or more other persons, and by means of one or more schemes, plans, and patterns intended to cause Jane Doe 1 to believe that if she did not perform such labor and services, Jane Doe 1 and one or more other persons would suffer serious harm, contrary to Title 18 USC sections 159A2 and 1589A2 and 1589A4. Criminal forfeiture allegation. The United States hereby gives notice to the defendants that upon their conviction of any of the offenses charged herein, the government will seek forfeiture in accordance with Title 18 USC 1594D of A, any property, real or personal, that was involved in, used, or intended to be used to commit or to facilitate the commission of such offenses, and any property traceable to such property, and B, any property, real or personal, constituting or derived from proceeds obtained directly or indirectly as a result of such offenses, or any property traceable to such property. If any of the above described forfeitable property, as a result of any act or omission of the defendants, A, cannot be located upon the exercise of due diligence, B, has been transferred or sold to or deposited with a third party, C, has been placed beyond the jurisdiction of the court, D, has been substantially diminished in value, or E, has been commingled with other property which cannot be divided without difficulty, it is the intent of the United States, pursuant to Title 21 USC Section 853P, to seek forfeiture of any other property of the defendants up to the value of the forfeitable property described in this forfeiture allegation. That is a mouthful. But this states that upon conviction, any property or things that they used to accomplish these goals would be forfeit to the U.S. government. If they had a sex dungeon in a sex house, for example, the sex house would be forfeited to the U.S. government. If they used cell phones or computers to contact people, if they drove cars or they had vans with giant blacked out windows or whatever to transport sex trafficking victims around, those would be forfeit to the U.S. government, and then the U.S. government could use those to abduct children and coerce them into sex trafficking, because I'm a couple drinks down and I don't trust the U.S. government. All right. What do we got? We're almost into the third hour. I'm going to close out the day with some gin. What about victory beer and a fridge in the sex dungeon? Will that be forfeit? Yes. Yes, absolutely. So, a brief aside to forfeiture. There are two types of asset forfeiture. There is this type of forfeiture, which rests upon the conviction of the crime, and that is probably okay. I mean, I hate saying anything that the government does which takes property from people is okay, but if you're guilty of a crime and you use property in the commission of a crime, I guess the government has an interest in taking it, whatever. But then there's the other type of civil asset forfeiture, which is where someone is suspected of a crime and their assets are forfeited to the police immediately. Oftentimes, this involves cash and this involves drugs. So if you just went to the bank, you withdrew, like you cash your paycheck, you got like $1,500 in your pocket or whatever, and you're going to go to the casino and gamble, or you're going to go buy a nice present for someone, you get pulled over, the police determine that you need to be arrested for drugs for whatever reason. They determine that the $1,500 in your wallet is actually from a drug transaction, even though you just got it from the bank, and you tell them that, and you produce the ATM receipt. If they determine it's from a drug transaction based on they say so, they can just take it from you and you will not get it back, even if you're not guilty in many cases. That is the type of civil asset forfeiture which should invoke armed revolution against the the state governments who impose it, because that is some garbage. But we'll have another video on that at some point. But civil asset forfeiture is disgusting. And cops out there watching, if you are, and you engage in that sort of practice, may you burn in the fires of hell, you scumbags. Forfeit stuff on conviction under statute, fine. Take stuff from people who aren't convicted yet, and you should catch fire. Fuzz Got Games, good question. What does the government do with forfeited criminal assets? If they are legal assets to own, like cars and real property, typically they would auction them off and use that money for various police activities. If they are contraband, they would use them for sting cell operations. Like if they confiscate pounds and pounds of heroin, for example, they would set up sting cells. If they confiscate firearms, they can set up sting cells. They actually, I don't believe, can resell firearms to the public. I might be wrong in that, or it might be state specific. Don't quote me. I don't know for sure, but I don't believe so. What they can do is set up sting cells for like illegal arms trades. ATF does this. Guys, so side story. I used to be a banker in downtown St. Paul, Wells Fargo in Minnesota. The ATF office in Minnesota was like right above us. And one of the ATF agents had an agency account at Wells Fargo. I'm probably doxing them. Screw you, ATF. I don't like you guys very much. You sold a bunch of weapons illegally to Mexico. Good plan. Thanks for killing Americans and Mexicans. Anyway, this guy was pretty cool, though. I liked him. He came down and he would actually withdraw money from certain accounts because they would go do sting buys of drugs. So that's what this type of stuff does, right? They will, if it's legal property and they get it, they will auction it off or sell it or utilize it. Like if they need a safe house or an asset house for some reason, you know, having real property can be useful. If they can repurpose a truck or a car into a fleet vehicle, maybe they'll do that. But a lot of times they'll just sell it at auction and use those funds for sting purchases, which then go to like, we're going to buy bombs from so-and-so who's manufacturing bombs to blow up things. And then they arrest them once they make the purchase. Firearms tend to be broken down and recycled for parts. Yeah, that's what I was thinking. I don't think they can actually sell them. I think they can do a sting sell, like I said, where the firearms don't actually change hands. But anyway, so there's the indictment. These are not good allegations. Let's see what hold on, sorry for that smacking sound. 1591A1 is 18 USC 1591A1. 1591. Let's see what the punishment for this is. The punishment for an offense under subsection A is, if the offense was effected by means of force, threats of force, fraud, or coercion described in subsection E2, or by any combination of such means, or if the person recruited, enticed, harbored, transported, provided, obtained, advertised, patronized, or solicited had not attained the age of 14 years at the time of such offense, by a fine under this title and imprisonment for any term of years not less than 15 years or for life. So, Miss Gatz could be going away for a very, very long time if this is the case. Where are we here? If I had the opportunity, I'd totally purchase Eric Harris's Tech 9 semi-automatic pistol from the ATF. All right. Yeah, 15 to life. 15 to life. Okay, so I have a bunch of... I apologize. The way I named these documents is not helpful. So this is her arraignment document. So these... This is not interested. This is not that interesting, guys. So Allison Mack... So defendant Keith Rainier is present and in custody. Allison Mack is present. She's not president. Mrs. Gatz. Miss Gatz is present, not in custody. And defense counsel Sean Buckley, Stephen Cobre, and William McGovern have been retained by Allison Mack. So this is the arraignment hearing. The defendant, Keith Rainier, is arraigned and pleads not guilty to the charges contained in this indictment. There will be voluminous discovery in this case, according to the government. And guys, if you want to know the best discovery, it is sex trafficking cult discovery. Like, how weird is that? I don't actually know that, but how... Sorry, Clay. How often do you get, like, not just trafficking, but fully organized sex cult discovery? Premium discovery. And whatever is public, I will try and track down. Voluminous. Also, according to the government, there may be a superseding indictment filed soon. So if there's a superseding indictment where if they determine there are greater crimes that have the same factual basis, because you can't, if you have a lesser included offense that has the same factual basis as a greater included offense, you typically have to drop the lesser crime. If that happens, they may have to refile. When they get some new evidence, they may determine that there's a bigger crime that has the same factual set as this crime. And in that case, it's going to be superseded, and we'll see at that point. All right. Also, according to maybe a superseding indictment filed soon. The next status conference in this matter is scheduled for Tuesday, June 12th at 11:30 a.m. Time is excluded under speedy trial, so they waive their right to a speedy trial. Act between today and June 12th for review of discovery and any plea negotiations or on consent of defendant Mack and over the objection of defendant Rainier. So Mack has consented to the waiver of speedy trial. Rainier has objected to it. Good job. Jury selection and trial is scheduled for Monday, October 1st, 2018. So that's how that goes. If it was a speedy trial, it would have to be started on May 4th, 2018 and stopped by June 12th, 2018. But they have waived that. So let's see. Next is the bond. This is Allison Mack. This was on April 24th. So there was a detention hearing set. She posted a bond of $5 million released on her, released to her parents. She's advised of bond conditions set by the court and signed the bond. Sureties sworn advised by bond obligations. Additional sureties to co-sign bond by 5/4/2018. So she is released, but I believe she is confined to her parents' house in California. That may be somewhere in here. Order of temporary detention pending hearing pursuant to Bail Reform Act. Okay, so that was before this. This is useless. Good job. I've got a bunch of letters and I don't know what they're for. I apologize. We're going to read that one in a second. That one might be juicy. Proposed protective order to govern the production of certain documents. Okay, so some of the documents are going to be redacted. That's where that is. Pardon me, guys. I didn't have time to review all of these documents in their entirety, so I'm working on it. So here's the release order for Mack. Okay, so defendant must remain in and may not leave the following areas without court permission. See attachment A. The defendant must avoid and not go to any of the following locations. See paragraph 5, which we're going to get to in a second. Defendant must surrender all passports to pretrial services. The defendant is placed under the supervision of the pretrial services agency, subject to the special conditions on the reverse, and subject to random visits by pretrial services officer at defendant's residence and or place of work. You have to be at your residence or your place of work. You cannot be somewhere else. If they show up and you're not there, jail. B, must report as directed by pretrial services. So you have random reporting. This is very common. So they will say, you better come see us within the next 24 hours. Maybe it's 72 hours. It kind of depends on the case. Subject to the following location restriction program with location monitoring as directed by pretrial services. GPS is listed here. That means she will have an ankle tag that has a GPS monitor in it and is home detention, restricted to home at all times except for attorney visits, court appearances, medical treatment, and then nothing else is checked. So no religious services, no employment, no school or training, no other activities. Cannot go to the store, cannot go to the movies, cannot go to the bar, cannot go to the liquor store. You're stuck at home. Have someone else bring you your booze. Defendant must pay all or part of the costs of any required testing, evaluation, treatment, and or location monitoring with personal funds based on ability to pay as determined by the court. Allison Mack is certainly able to pay this stuff, and she will have to cover all of the costs. Other conditions, see attachment A, must reside at redacted. That is her parents' home address. So you know. I'm sure it says it somewhere else, but it is her parents' home address. What about food? You better have someone bring you food. You better order in. Her parents' home address is in California. I'm sure she'll be fine. That's because we know what happens at her religious gatherings. Absolutely. Party time. So appearance bond, located premises located at attachment B. Also agree to execute a confession of judgment, mortgage, or lien in form approved by the U.S. Attorney, which shall be duly filed with the proper local and state authorities on or before see attachment B. Let's see. Melinda Mack is the surety, and Jonathan Mack is a surety. So those must be her parents who have promised to do this on behalf of Allison, the defendant. So they're also saying that, yeah, she's going to be at our place, and we will monitor that. Let's go to attachment A. Defendant must remain in and may not leave the Central District of California, Eastern District of New York, and the Southern District of New York. She can be in any one of those places. See additional conditions in paragraph 5 below. Defendant will not directly or indirectly associate or have contact outside the presence of her counsel with her co-defendants, alleged co-conspirators, or any individual currently or formerly employed by or associated with NXIVM or any affiliated or constituent entity, which I have heard Knife Edge Media is an affiliated entity of NXIVM. If someone wants to confirm or deny that in the chat, let me know. But that's what I have heard. Defendant is subject to electronic monitoring and home detention. See order setting conditions of release. Defendant is permitted to use only one cellular telephone that will be provided to and approved by PTS to make and receive calls to and from phone numbers agreed to by counsel for the defendant and the government. That's going to be a flip phone, and it's going to be terrible. The defendant may not use a computer or access the internet through any means. Like, imagine not being able to use the internet. How are you going to run your sex cult? Except she may use a single internet-capable device approved and monitored by PTS as may be necessary to communicate with PTS, defense counsel, a treatment provider, or anyone else with prior approval from PTS and the government. So no Pornhub for Allison Mack. Attachment B. The $5 million appearance bond shall be secured by mortgages in favor of the United States of America on the following real property with a combined estimated market value of approximately $1.73 million. That's her parents' house. So she better show up or her parents lose their property. Lien on an individual retirement account owned by the defendant in the amount of $585,000. And Allison, I gotta figure you had more money to put into an IRA than that. The $5 million appearance bond should be signed by the defendant and co-signed by the following individuals: Melinda Mack and Jonathan Mack. Dude, I can't pronounce that name at all. Is that Julia's Cuadro? They should redefine the no internet bit. My toaster connects to Wi-Fi. Do I just not make toast anymore? Yeah, with the Internet of Things, it sure makes that sort of interesting. Finally, here's the release order, which is substantially the same as the other one. So I'm not gonna redo that. Same thing. Let's see. Okay. Next. And I apologize for these being out of order, guys. So this is a letter just continuing the May 3rd hearing to May 4th. This is the bond set at $5 million. What do we have? Letter. I was going to read the letter. So this is the government letter. This is, let's see what get in. Please shout out Julia's Cuadro so he can STFU. Is it Julihez? I hope that's right. Man, I don't know how to pronounce that that ramshackle set of consonants. What stops Allison from going on Pornhub with her mommy and daddy's computer? If they find out she has done that, she's in violation of her release conditions. That means she's in forfeiture of bail, potentially, which means her parents' house goes bye-bye. And also she can be hauled into jail for the rest of the term. All right. So this is from the government. To the Honorable Cheryl L. Pollack, U.S. Magistrates Judge. Oh, does that answer that question from earlier? Let's see. Dear Judge Pollack, the government respectfully submits this letter to set forth the government's position with respect to bail in anticipation of defendant Allison Mack's arraignment on the above captioned indictment. For the reasons set forth below, the government respectfully submits that Mack poses a risk of danger and a risk of flight and should only be released pursuant to a substantial, heavily secured bond commensurate with Mack's financial resources signed by a number of financially responsible sureties unaffiliated with NXIVM and subject to additional conditions of release, including, among others, home detention with electronic monitoring. Here's the background. This is why I have this letter. Background. On April 19th, 2018, a grand jury sitting in this district returned an indictment charging Keith Raniere and Allison Mack with sex trafficking conspiracy, and conspiracy to commit forced labor. That labor being sex labor. As described in the complaint filed against Heath Raniere on February 14th, 2018, in which Mack, hereinafter the defendant, is referred to as CC1, the defendant is alleged to have recruited and persuaded young women into joining a secret organization called DOS, not to be confused with Microsoft DOS, or maybe it is. Or The Vow. The Vow. Guys, name it like pumpkins or something. I don't know. DOS is comprised of masters who recruit and command groups of slaves. It is also a mainframe system, a non-graphic user interface of Microsoft that I sorely miss. I love the days of DOS. The defendant recruited prospective DOS slaves to join DOS by describing it as a women's empowerment group or sorority. The defendant had women provide her with collateral, which consisted of naked photographs. Let me give a pro tip out there, guys. If you're trying to join a sorority or fraternal organization or a an empowerment group, and the collateral is nudes, please send nudes. You're not joining the right group. I'm gonna just suggest that. Okay. Photographs, assets, criminal confessions, and other damaging information to prevent the women from leaving the group or disclosing its existence to others. Once they joined, DOS recruits were required to provide additional collateral, which they did, fearing that their original collateral would be released. And side note, I have dealt with people who have been in blackmail situations involving, if you guys have seen that, if nudes are liquid assets, you're not working out hard enough. If you guys have seen that episode of Black Mirror where the kid looks up the like kitty porn and they get the video of him masturbating and then they blackmail him into that. I actually have dealt with a situation like that. If you ever find yourself in that situation, do not pay the blackmailers, because once you pay them, they just ask for more money because they still have your video of you doing what you're doing. Sorry, Tess, for the spoilers. I'm just trying to help. If someone is telling you that they have something negative about you, they're blackmailing you, and they ask for money, the thing that always happens in every case is once you pay them, they ask for more. Make peace with the fact that they might release it and move on with your life. Tell all your friends, hey, you're about to get a bunch of penis pictures from me. Sorry, don't be jealous. That's how it's going to be. And to that point, don't send nude pictures to people you don't know. Probably don't take nude pictures on your phone to be safe or on your webcam. That's the safest aspect. If you want to do nudes to a loved one, use a Polaroid. What I do is post it first. There you go. And that's also, you know, if you get out in front of the problem and you post it first and be like, what's up now? Now you got to pay me. That's effective. All right. As set forth in the complaint. DOS slaves understood that their participation in DOS was a lifetime commitment, and that if they disclosed their participation in DOS, left DOS. I haven't seen the criminal complaint. I've only seen the indictment against Mack. I bet it's in the Keith Raniere documents. I'll see if I can find that for a future video. DOS was a lifetime commitment if they disclosed their participation in DOS, left DOS, or failed to complete assignments given to them by their masters. Their collateral could be released. DOS masters, including the defendant, benefited financially from recruiting and maintaining DOS slaves. DOS slaves were often required to perform acts of care for their masters and to pay tribute to their masters, including by performing labor and other services for which the DOS slaves were not compensated. Excuse me. In addition, the defendant directed some DOS slaves, including Jane Doe 1, to have sex with Keith Raniere, whose participation in DOS was not disclosed. DOS masters, including the defendant, groomed DOS slaves for sex with Raniere by requiring DOS slaves to adhere to extremely restrictive diets and not remove their pubic hair, in accordance with Raniere's sexual preferences. All right. And by requiring them to remain celibate and not to masturbate. DOS masters, including the defendant, who directed their slaves to have sex with Raniere, received financial benefits in the form of continued status and participation in DOS, as well as financial opportunities from Raniere. Clay, if you send me a nude via Polaroid, I'm going to send you a fist in the face. DOS masters, including the defendant, also demanded that DOS slaves participate in readiness drills, which required them to respond to their masters any time of day or night, causing DOS slaves to be seriously sleep deprived. DOS slaves were also branded in their pelvic regions with a cauterizing pen with a symbol that, unbeknownst to them, incorporated Raniere's initials. For the reasons set forth below, the government respectfully submits that, given the serious risk of flight and danger to the community that the defendant poses, the defendant should be released only pursuant to substantial secured bond signed by several financially responsible U.S.-based sureties who are unaffiliated with NXIVM. In addition, the court should order home confinement with electronic monitoring. And then there's a legal argument. But really, guys, this is just juicy details. I don't think there's anything else in here. Let's see what they say about the defendant's guilt, because that just intrigued me a little bit. Finally, the weight of the evidence against the defendant is strong. The government's evidence include witness testimony that is corroborated by, among other evidence, electronic communications between the defendant and her co-conspirators, and other documentary evidence and records. These electronic communications evidence the defendant's involvement in DOS recruitment, her participation in conducting readiness drills, and the assignment of tasks and penances, and other efforts aimed at the continued manipulation and coercion of DOS slaves. This factor, too, strongly favors detention in the absence of a significant bail package. All right, guys. The government thinks they have a strong case against Allison Mack, otherwise known as Miss Gatz. Kind of looks rough for Mack. I don't know what her defense attorneys are planning, but I would guess, and I'm going to base this on the fact that she waived the right to a speedy trial and that homeboy Vanguard did not waive his right to a speedy trial or objected to the waiver of right to speedy trial, whatever that happened to be, that Mack is going to throw Raniere under the bus. And this is an interesting sort of thing when you have co-defendants under the same set of facts. Oftentimes, a good argument for whatever defendant you may be representing is to blame it all on the other person. And I'm betting Mack is going to suggest that she was a DOS slave just like the Jane Does, that she had submitted collateral to Raniere, was in his thrall, was not able to leave, was in fear for her personal safety. This is based on not having any of the information beyond what you guys have seen today, because that's about all I've got. That's how I would run this case. Now, there may be all sorts of other information out there that make my theory ridiculous, but based on the fact that they have differing agreements on the speed of trial, they've already set a precedent that they're opposing parties. And if you're opposing a co-defendant, you're probably going to blame the co-defendant for as much as you can. And so I would wager that that's going to be Mack's defense. And based on what I've seen so far, that's her best defense is, look, I was forced into it just like these other girls. There's a hierarchy that goes beyond masters. Masters is a term of dominance. However, we are at the subject of Rainier, who is the overlord. He is the controller. He's the dungeon master, or whatever term they want to come up with, because they're not very original. He is the guy controlling everybody. He has everybody's information. And I have been trying to leave this cult forever, but I couldn't. And if I didn't do what was told, my family was going to be in danger. I was going to be in danger. All sorts of stuff would happen. Sort of like how Lilo threw Regina George under the bus. Dude, don't you bring Mean Girls into this. So, anyway, that is the Allison Mack case thus far. It is another case. Oh, of course I miss D&D. Man, if I had time to play D&D, Tess, I would be in every game. I'd be in every game. That is the Allison Mack case that we have so far. We won't have substantial updates until June 12th. I will be monitoring for discovery. If you guys are interested, if you guys also monitor this case, if this is something you're interested in, for that matter, if any of these cases that I cover, you have particular interest in, monitor them with me in case I miss it. I have a lot of cases that we are covering right now. It's a little overwhelming to try and follow all of them. So if you guys are also following stuff, when it comes out, don't hesitate to send it to me. Who cares if I've already seen it? I might not have. So send it to me. I'm happy to follow up. If there's something interesting, we'll do a video on it. Go ahead and send me that information. Help me out. If we can crowdsource following these cases, it will make my life so much easier. I've got some vacations coming up, which is going to make my monitoring a little bit more difficult as I'm on the road, but I will still be doing videos, although I'm probably going to have to reschedule a live stream or two because I think I'll be driving across the flipping earth on a Friday coming up. So I will keep you guys apprised of what the live stream alternate schedule will be, but just know that as I go on vacation, I will bring all sorts of liquor with me, and I will also bring an ample streaming computer. So we'll still have live streams, although they may not be on Fridays, and there will still be video content released. But if you guys have in lowerarchy, yes, it's men are better than women. Should we call their tier system lowerarchy? Rude, Clay. Rude. If you guys have any other questions, ask them now, because the stream is going to end in the very near future, and I will be moving on to Twitch and Twitch. So if you, in the description of this video, as well as most of my recent videos, there is a Twitch TV /Rekieta Law or whatever, Nick Rekieta. I don't remember. Too much booze, I guess. You can go there. I'm going to grab a snack, some food to help soak up some of the gin. And then I will move on to Twitch. And I will be either playing Skyrim, and I've got 2 possible characters, and I'm leaning towards the Gavel at the moment. But the Gavel will be a character that only wears robes and wields a 2-handed hammer and judges everybody as harshly as possible. Or I will do an attorney, or the lawyer character in Skyrim, which only uses speechcraft and illusion, modded speechcraft and illusion, so that will and tries not to kill anybody, but makes other people kill them for him, like attorneys do. So, no problem, Kenster. Well, thanks for asking many questions. Are either of them stealth archers with restoration skills? None of them will be stealth archers with restoration skills. So no. Or I might play some, I might start out with some Dragon Ball Z, Dragon Ball Fighter Z, so you can make fun of me. But the Twitch stream will probably start in 10 to 15 minutes after this stream ends, just so I can make some sort of food and shove it in my gullet, because I'm really, really hungry. Do a cheers with me before you leave to your YouTube success and Tess's oddly... Oh, Clay. All right. Clay, this is a cheers to you, although I do not endorse and cannot endorse the latter portion of your statement, as I have no idea of the shape of said nipples. Never should have come here. Never should have come here. Yeah, I'll probably start with some Fighter Z just to get warmed up, and then move into the Skyrim game a little bit later. Thank you, Andrew, for the compliments. Later, Sean. Have a good night, buddy. Man, I hope to make it to your neck of the woods at some point, because we need to fire some guns, buddy. Favorite D&D race class? Oh man, I don't know. I've been thinking about carrying a knife in my boot. I'm tired of getting disarmed. Mad Cucks, you need to be careful, like as a lawyer, not your lawyer specifically, but as a lawyer, check with the laws in your state for carrying knives. Depending on the knife itself, you may not be able to carry it concealed in a boot. You may have to, depending on the state also, you may not be able to carry it concealed in a boot. You may have to carry it open in a sheath, depending on the size of knife, the type of knife, stuff like that. Oh, that's a Skyrim quote. Oh, okay. Sorry. I know zero Skyrim quotes because I always skip all the dialogue. As to the question of how much money Mac has, I know I'm far behind. She probably had to pay into NX. You've conquered Skyrim, dude. Mad Cucks, buddy. I'm gonna play some Morrowind at some point when I get really into it, and I'm gonna kill everybody, every NPC in that stupid game. I have so many more spots to keep knives ever since the surgery. Oh, Dax, Desi. But so this is just before I know, like, half of you have left because I'm bad at managing this stuff. Actually, I don't know if I don't know if any of you have left. I'm not even watching the thing. Where are we? A chunk of people have left, but there's still a significant remaining. If you have questions about these cases, come on to the Twitch stream and ask me, and I will answer questions on the Twitch stream, because I would love to have things to answer on the Twitch stream as well, because usually it's just me being like, I'm gonna go over here, and not really having much. So I'm really selling that Twitch stream pretty hard, but come to the Twitch stream. Come ask questions about cases, any case I'm covering, anything. Interact with me on there. I'd love to do that. So yeah. Anyway, guys, I'm gonna blank out the screen, so it's gonna go black, and then once I see it go black on the stream, which is a couple minutes delayed, I'll end it. But I'm gonna stop talking for now. So thank you so much for coming to the stream. Give me 10 to 15 minutes on Twitch, and I will start up there as soon as I get some food. And I'll eat the food here on Twitch because that's professional. But I'm blanking the screen out. Once it goes blank on my side, I'm gonna shut it down. Thank you so much for the stream as always, and hit the like and subscribe button. Share this with your friend, of course, if you think they'd be interested in any of this stuff. And thanks for helping me grow this channel, guys. This is so much more fun than I ever thought it would be. So, and I am trying to get Lady Rackets back on the stream, but she's just had a very busy schedule and is not generally awake for these anymore. But we'll see soon. Anyways, guys, peace. Talk to you soon.